Hi, my name is Neil Pederson. I'm one of the owners of Pederson and Sons Surety Bond Agency, and I've been doing a multi-part series on appellate bonds. Last week, I covered why you would use an appellate bond, which is to stay the execution of a judgment pending appeal. This week, I want to talk about what happens when a judgment's being executed upon. And now, I'm not an attorney. I'm just giving you a general overview of what that looks like and why that causes problems related to a bonding perspective. So in, let's say, New York State, although this may apply to some other jurisdictions, but for today, I'm going to just speak to you about New York since we're going to keep it relatively simple so that we can do other jurisdictions at a later date. New York State, once a judgment's entered, the other side can execute upon it. What that means is that they could levy your bank accounts, they can restrain your assets, they can have the sheriff seize your assets. And what does that mean from a bonding perspective? Well, if you had to commit capital or contribute assets or secure assets to secure a bond, and they're restrained or they're encumbered by the judgment creditor's levy, well, you cannot use them to get the bond. So if you know a judgment's coming down against your client, you want to have the bond lined up ahead of time. Another reason is that the sheriff secures or takes the assets they're entitled to sheriff's poundage, which I believe is about 5.5% per year. Don't quote me on that. But if you had $1 million judgment being executed upon by the sheriff and they're entitled to their poundage, that's about $55,000. And if they restrained your client's assets, they may not be able to get the bond. If they are able to get the bond, the sheriff's still entitled to that money. On top of things, once the bond's filed, you then have to motion the court to have the assets that were restrained unrestrained and the restraint lifted. It turns into an absolute mess, and you would have an unhappy client if the opposing party is executing upon your client's assets. What you can do is file a bond and have a notice of appeal to obtain the automatic stay pursuant to CPLR 5519 and secure the judgment pending appeal. Today, I have an emergency bond that I just issued for a client for an appeal, and you want to use a broker like myself that knows exactly what is needed to get the bond issued immediately so that your client's assets are protected. We understand what's at stake and at Pederson and Sons, we try to take the bonding complications and make them simple. Give me a call, Neil Pederson, Pederson and Sons Bonding, 212-227-7277. Thank you. Bye.